Welcome members to the 13th meeting in 2013 of the Subordinate-Legislation Committee, and ask members to turn off any mobile phones, please. Agenda item 1 is a decision on taking business in private. It's proposed that the committee takes item 7 in private. This is consideration of the committee's third quarterly report for the parliamentary year of 2013-14. Do members agree to take item 7 in private, please? Thank you. Agenda item 2 is instruments subject to affirmative procedure. Children's Hearings Scotland Act 2011, Rules of Procedure in Children's Hearings Rules 2013 draft. Rule 9 appears to have been made by an unusual or unexpected use of the powers in section 177 of the Act to make rules about the procedure relating to the children's hearings, combined with the powers in section 1952 to make incidental, supplementary or consequential provision. The committee may consider that it would have been more usual or expected use of powers to have made the provisions contained in Rule 9 by regulation under Section 34, which specifically deals with imposing additional requirements on safeguarders. However, this does not appear to affect the validity of the rule. The Scottish Government adopted this approach as it considers the matter generally related to procedural issues, but the committee may consider Rule 9 to be in the nature of a substantive requirement. The committee may also wish to note a couple of matters. Firstly, as a result of observations made by the legal advisor in connection with Rule 56, the Scottish Government has withdrawn the rules which were initially laid on the 15th of April and has relayed them on the 23rd of April with changes to that rule. Secondly, Rule 33 sets out requirements for the provision of information in advance of certain hearings to specified persons involved in the hearing. This applies where sections 109.7, 115.5 or 117.5 of the 2011 Act applies. Sections 115.5 and 117.5 are yet to be inserted into the Act by the Children's Hearings Scotland Act 2011 Modification of Primary Legislation Order 2013. This order has yet to be laid in Parliament. Without sight of this further instrument, the Parliament is not able to be wholly clear as to the application and effect of Rule 33 in the period permitted for the scrutiny of current rules. Whilst the committee may wish to welcome the government to supply the details of these subsections, the committee may also wish to encourage the Scottish Government to consider how such references to provisions yet to be made could be avoided in the programming of legislation. Finally, on this instrument, Part 21 of the rules makes specific provisions for hearings arranged under the Children's Hearings Scotland Act 2011, Implementation of Secure Accommodation Authorisation Scotland Regulations 2013, and cross-refers in several places to these regulations. These regulations have also yet to be laid in Parliament. Without sight of this further instrument, as laid and published, the Parliament is not able to be wholly clear as to the application and effect of Part 21 in the period permitted for scrutiny of the current rules. Does the committee therefore agree to draw the rules to the attention of the Parliament on reporting ground G, as Rule 9 has been made by what appears to be an unusual or unexpected use of the powers conferred by the parent statute, which is the Children's Hearings Scotland Act 2011? Thank you. No points have been raised by our legal advisors on the Children's Hearings Scotland Act 2011 review of contract directions and definition of relevant person, Order 2013 draft, nor on the Public Services Reform Scotland Act 2010 Modification Order 2013 draft. Is the committee content with these instruments?
Content.
Thank you. Agenda item 3, instruments subject to negative procedure. The Firemen's Pension Scheme, Amendment Scotland Order 2013, SSI 2013-128. There has been a failure to lay the instrument at least 28 days before it comes into force, as required by Section 28.2 of the Interpretation and Legislative Reform Act, Scotland Act 2010. The committee may wish to note that as a result of the policy adopted, the instrument required to come into force on May the 1st, 2013, and that its making was dependent on receipt of confirmation from the Department of Communities and Local Government of the applicable contribution rates, which occurred on the 26th of March. The committee may accordingly consider the failure to be acceptable, having regard to the circumstances in which the Scottish ministers found themselves. Does the committee agree to draw the instrument to the attention of the Parliament on reporting ground J, as there has been a failure to lay the instrument at least 28 days before it comes into force, as required by Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010?
Agree.
Does the committee find the explanation given by the Scottish Government for the failure to lay the instrument at least 28 days before it comes into force to be acceptable?
Agreed.
Firefighters Pension Scheme Scotland Amendment Order 2013 SSI 2013-129. There's been a failure to lay the instrument at least 28 days before it comes into force, as required by Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010. As with SSI 2013-128, which we have just considered, the instrument required to come into force on the 1st of May 2013, given that its making was dependent upon receipt of confirmation from the Department for Communities and Local Government of applicable contribution rates, which occurred on the 26th of March. The committee may therefore find the failure to be acceptable, having regard to the circumstances in which the Scottish ministers found themselves. Does the committee agree to draw the instrument to the attention of the Parliament on reporting grounds J, as there's been a failure to lay the instrument at least 28 days before it comes into force, as required by Section 28.2 of the Interpretation and Legislative Reform Scotland Act 2010?
Agreed.
Does the committee find the explanation given by the Scottish Government for the failure to lay the instrument at least 28 days before it comes in force to be acceptable?
Agreed.
No points have been raised by our legal advisers on the Action Programme for Nitrate Vulnerable Zones Scotland Amendment Regulations 2013 SSI 2013-123, nor on the Freedom of Information Scotland Act 2002 Scottish Public Authorities Amendment Order 2013 SSI 2013-126, nor on the Environmental Information Scotland Amendment Regulations 2013 SSI 2013-127. Is the committee content with those instruments, please?
Content.
Yeah. Which brings us to agenda item 4, which is instruments not subject to any parliamentary procedure. No points have been raised by our legal advisers on the Scottish Civil Justice Council and Criminal Legal Assistance Act 2013, Commencement Number 1, Transitional and Transitory Provisions Order 2013, SSI 2013-124. Is the committee content with that instrument, please?
Consent.
Agenda item 5, the Land and Buildings Transaction Tax Scotland Bill. This item of business is consideration of the Scottish Government's response to the committee's Stage 1 report on the bill. Members will have seen the briefing paper and the response from the Scottish Government. Do members have any comments, or are we content to note the response and, if necessary, reconsider the bill after Stage 2?
Content.
Mike?
To make the point that this provides a, I think a fairly good example of perhaps the lead committee not being fully aware of this committee's concerns in terms of, my understanding of this is restricted to having read the committee's report, and although they do make reference to this committee's observations, I'm not convinced that they fully understand the implications of what we were saying, but I do welcome the government's response to what this committee has said with regard to or this committee's recommendations, and to come back with some idea of a provisional affirmative procedure, I think is to be welcomed. But I raise it because I think in the context of discussions about how we can work more effectively with lead committees, I think this is, it's worth noting in that respect.
I think it's probably worth noting that our concerns were, of course, referred to on a couple of occasions during the Stage 1 debate. So therefore, it's not a matter that's passed Parliament by.
Okay, are we content to leave it at that for the moment?
I would endorse that. I think it's important to acknowledge that the government has taken account of what we said,
yes,
and we therefore welcome that.
Yep.
And look forward to what they bring forward and consideration of that in due course.
Indeed. Thank you. We're content with that. Thank you. Which brings us to agenda item 6. This item of business is consideration of an update on litigation, and for the sake of the record, let me be clear that the case is Davis and another trading as All Stars Nursery and the Scottish Commission for the Regulation of Care Scotland 2013 United Kingdom Supreme Court 12. Consideration of this litigation concerns the transitional arrangements for the transfer of regulation of care services from the Scottish Commission for the Regulation of Care, which we'll hereinafter refer to as the Commission, to Social Care and Social Work Improvement Scotland, generally known as SCISWIS, under the Public Services Reform Scotland Act 2010. In 2012, the judges of the Inner House of the Court of Session were divided in their interpretation of the manner in which two orders concerning transitional arrangements dealt with regulatory notices which had been served by the Commission but remained under dispute at the time the Commission was dissolved. The Court, and in particular Lord Marnock, the judge in the minority, was also critical of the drafting of the orders and the scrutiny applied by the Parliament. The case was subsequently appealed to the Supreme Court, which agreed with Lord Marnock, identifying a gap in the transitional provisions. Prior to this Davies case, a similar transitional gap was identified by the courts in IO and LO versus the Aberdeen City Council case. In this judgment, Lord Hardy criticised the scrutiny applied to that instrument by the Scottish Parliament and suggested that procedures for considering transitional provisions should be reviewed by the then Scottish Executive and the Scottish Parliament. In the light of the IO case and the Scottish Government committing to provide the committees with executive notes, which are now policy notes, to identify commencement orders that contain complex provisions, the Scottish Government also agreed to undertake to provide a full 40 days between making the date and the appointed date for the Commission commencement orders which contain such complex provisions to allow for as much time for scrutiny as possible. Whilst these arrangements thus appear to be working satisfactorily, the committee may think it appropriate to ask the Scottish Government to comment on the outcome of the Davies case and on whether it intends to further review its practice in regard to transitional arrangements. Further to this, the committee may wish to consider how this issue can be highlighted more widely within the Parliament, and I suggest that it may be helpful for me to raise the issue at the Conveners Group meeting in the first instance, with the view to the committee's legal advisers providing a briefing to the conveners. I wonder whether members have other comments on this before we address specific questions. Hans Alle.
Just one, and that is perhaps we would be able to share the level of importance we would give any particular item. That may help committee members in focusing on the document in front of them.
Other thoughts on how we might take this forward? John?
Yes, I think this is quite a serious issue for the Parliament. Lord Hardy's comments are really quite withering, but let us endeavour to learn from this experience. There was an unusual set of circumstances at the time when this piece of legislation was under scrutiny at the end of session 3, an unusually high workload for both the subject committee and indeed this committee. And to be fair, it did stand examination, shall we say, by the courts right up to the Court of Session, who agreed by a majority, notwithstanding the fact that that was overturned by the Supreme Court thereafter. Undoubtedly, this has put a lot of people and a lot of parties to a lot of expense. But I think we should endeavour to take the positive from this and learn from this and continue to emphasise to all committees perhaps the importance of this committee in the comments it makes, and how because we did point out that this was complicated at that time in 2009, although we weren't on this committee at that time, but perhaps we just didn't put enough emphasis on how this was going to be just so difficult in terms of implementation, which has led to the problems that we have experienced.
very much endorse what John Scott has said. I think what has come out of this in parliamentary and government process, which is to be welcomed, is the agreement that there will be policy notes when there are complex transitional arrangements, and that there will be 40 days for Parliament to consider that. I think we've seen some evidence that we've talked about before in this committee that there is a greater awareness of the significance of issues we draw to attention, Parliament's attention to via other committees and otherwise. But I think it just does illustrate the need for continued vigilance and care in what we do. And I think the proposal to basically to write to the Scottish Government is one that we should take, albeit I expect that we'll hear that what can be done is already agreed, but it's now in the context of the Supreme Court having made a decision.
So does the committee agree to write to the Scottish Government inviting its views on the outcome of the Davis case and on whether it is reviewing its practice in relation to transitional arrangements as a result? Agree. That's the right thing to do. Does the committee also agree to raise the profile of the issue in Parliament and in the first instance by raising the issue with the conveners group? It seems to be a way forward. I would say, in passing, I also think there is one other good thing in there, which is that the Supreme Court clearly noticed that if it takes 5 years for a case to get to them, that people have been seriously inconvenienced. I think that's an extremely good observation, and I hope that's one they'll work on. At that point, I think we move the meeting into private for agenda item 7. Thank you.